Just to say that if you are enjoying this podcast and you'd like to give us a bit of extra support, you can head over to our Support Us page where you can give us a tip, or you can follow us on Patreon and you can download our newsletter. And we really appreciate everybody who gives us a bit of extra support there.
To commit crimes against humanity in a systematic way requires money and support. And the state keep track of that support, either financial or physical. The information is somewhere.
No one can act with impunity.
These are crimes that are beyond the pale.
We are talking about human beings. We're not talking about numbers.
We need a court. That's as simple as that.
This is Asymmetrical Haircuts, your international justice podcast with Janet Anderson and Stephanie van den Berg.
All rise.
Hi, Janet.
Hi, Steph. We seem to be in a sort of inadvertent mini-series at the moment connected to Argentina. Last month, we touched on, I think it was the second time that we'd done this, the possibility for accountability for killings and for torture in Venezuela via Argentine courts.
Yeah, plus we've just put out our podcast with Gisunia about the first possible investigation into the crackdown in Iran via the Argentinian legal system.
And of course, we haven't forgotten Myanmar, because while the hearings were happening at the International Court of Justice last month, we've been reminding ourselves of the case that we've already covered, where arrest warrants have been issued by Argentine courts for Myanmar top leaders.
But meanwhile, you took it upon yourself to organize this podcast on corporate crimes in Argentina.
Yeah, this is an area that we've looked at, albeit quite briefly. We've followed two very different but interesting cases, which become entwined in my brain because they both begin with L, Lundin and Lafarge, which are about responsibility for corporate crime. So it was when Roy Bakhmutsky, hi Roy, welcome to the show.
Hi there, thanks so much for having me. Really an honor to be on. I've been an avid listener for years, so it's incredible to be with you.
Great. Welcome. Roy did what I would encourage people to do. He sent kind of a "what about us" message, pointing out that Amnesty International, where he works, has a new corporate crimes handbook. It's all about lessons learnt, how to tackle both the advocacy and the legal work around getting these kind of trials going. And to be honest, I mean, handbooks, I always think, meh, who cares? But then I looked through it and, of course, I spotted Argentina again and again. And I thought, what is going on with this place? It has up the top of the handbook, if people want to have a look at it, we'll put a link in with two summaries of cases. And I thought that I'd ask Steph, not as Stephopedia, but as a reader of the summaries, to explain what these two cases are.
So this is the summary from Amnesty, which also Janet has put in the script in the smallest possible font. So one is Ford, or former Ford, and this is Argentinian prosecutors indicted the accused who were convicted in 2018 for complicities in crimes against humanity, including torture and illegal deprivation of liberty committed by the Argentinian state authorities during the military dictatorship in the late 1970s as a result of the executives identifying workers and providing a space for their detention at the Ford facility near Buenos Aires. And these defendants were sentenced to over 10 years imprisoned.
And that case is still ongoing.
Yeah.
The conviction was appealed, and it's a case against the former director and security manager. What about the La Fronterita case? Steph, if you can read my incredibly small typescript.
In the La Fronterita case, it's about the CEO and 5 other members of the board of directors of the La Fronterita sugar mill. And the Argentinian prosecutors indicted these accused in 2012 for complicity in crimes against humanity, including alleged killings, tortured, and enforced disappearances, again committed by the Argentinian state authorities during the period of its military dictatorship in the 1970s and the 1980s. And again, this as a result of the executives identifying workers, supplying company-owned vehicles to military personnel, and granting military access to company facilities. It says also 4 of the 6 persons originally accused are no longer part of the proceedings due to death or illness. And they name an NGO, ANDGES, which represents the family members and one of the victims in the case and has participated in the criminal proceedings. It's an ongoing case and it is proceeding to trial.
So joining us alongside Roy is Gabriel Pereira. Hi, Gabriel.
Hi, both. Thank you very much for inviting us to this podcast. It's quite an honor to be here.
And Gabriel is directly connected to that La Fronterita case because he's the lead attorney for the Argentine human rights organization that you mentioned, Steph Andes. And he also worked on the Corporate Crimes Handbook. And he was particularly looking at overseeing the kind of lessons learned across all of the Latin American cases that are summarized there. I know this was a really long intro, but I hope that by just getting all of that stuff down, we can just get into the heart of the matter. So I wanted to start with you, Gabrielle, to say, I mean, I think it's pretty obvious as a question. These are all crimes from the 1970s and 1980s. Understood that was a very difficult and important time, this dictatorship in Argentina. But why are you still pursuing these? I mean, it's nearly half a century later. And as we've already seen, some defendants have died and really they're pretty old. So what are you up to?
These cases are part of what we call and has been established by the Argentine Supreme Court. They are part of the systematic plan of perpetration of crime against humanity during the last dictatorship. So these two cases are part of a universe of around 26 criminal cases, which are still ongoing in Argentina. And we are now litigating those cases because we couldn't do it before due to amnesty laws and pardons during the 80s. So Argentina started what we call the transitional justice process in the early 80s, and due to military pressure, two amnesty laws and several pardons were passed at the late 80s. So during the 90s, we have what we call the impunity period. And it was not only until the early 21st century in which the Supreme Court ruled the amnesty law as unconstitutional. Before the Supreme Court ruling, there were some pronunciation by the Inter-American Commission of Human Rights. There were some trials taking place in Mexico, Italy, France, US, and other countries in which Argentine military officers were convicted for perpetration of crimes against humanity. So the thing is that 2005, when the Supreme Court ruled the unconstitutionality of the amnesty law, was a moment in which they reopened the trial phase in a way, so we could restart cases at that point. And the thing is that in that particular moment, the trials which were reopened, they were directed, the accusation were against state officers. But there was kind of a very important push from human rights movement to widen our approach of what state terrorism means in Latin American dictatorship.
So first round is state, but you wanted to push it a bit further. What were you pushing for?
We push for corporate complicity. You know, the idea that these crimes against humanity were committed not only in terms of political repression, but also as part of economic interest. So there is where many human rights activists and survivors started pushing the cases against economic actors. And this is part of the discussion that we have today. The legal strategy has been to include the behavior of private actors as part of the systematic plan. So the challenge is to show that what they did was a crucial element of a series of events that were part of this systematic plan that occurred in Argentina to commit crimes against humanity during the 70s, early 80s. That's the reason that we are litigating those cases now. This because we couldn't do it earlier. Even though the Truth Commission in Argentina in the 80s already reported 7 companies as part of the systematic plan developed during the dictatorship.
That's a lot of things that you're saying at the same time. Let's pick out one element of that and get Roy in here. Roy, Amnesty International, the organization, to set it apart from the amnesty laws that Gabrielle was all talking about, as an amicus in the Fronterita case, has argued that the delay, that it took so long for this case to actually come forward, was an added violation of human rights. Can you tell us a little bit about how that submission went and how it helped in the case?
Maybe I'll say up front that when we're talking about the delay in that amicus brief that we filed, we're referring to the delay after, I think Gabriel said 2005, when kind of these proceedings began. It's now 2026, so we're decades down the line. Our strategy in submitting that amicus brief in the La Fronterita case was twofold. So first, we wanted the Argentinian court to know that the international community, in this case Amnesty International, was observing the case and that the court's decision will be subject to public scrutiny. So our partners at Andes explained that after many years of delays in the criminal proceedings, culminating in a need to confirm the charges in the indictment against the corporate executives for the second time, there were concerns about irregularities in the way this was being adjudicated. Essentially, the legal process was stuck, and some judges may have preferred it that way. And we at Amnesty believe that sunlight is the best disinfectant. So more important than what exactly we argued is the fact that we argued it. And we're seen to be paying close attention to the case. And second, we wanted the Argentinian court to be aware of Argentina's obligation to provide effective remedy for human rights violations. And as such, the risk that further delay in the proceedings had already been ongoing for decades would mean that Argentina may be failing to provide effective remedy as it's required to under international law. In terms of how our amicus brief helped, I mean, I defer to Gabriel because he was involved in the litigation more directly than I was. But my impression was that the La Fronterita case proceeded to trial soon after our filing. And I can't say for sure what role our filing played in that decision. It's hard to get into the judges' heads. Maybe Gabriel has a better sense. But interestingly, the company's defense lawyers seemed concerned by our brief, and that's generally quite telling. They responded by claiming that the intervention of various NGOs, including Amnesty, demonstrated the defense in that case was disadvantaged in the litigation by having to fend off the state prosecutors and the victims' lawyers and the NGOs. And they saw that as demonstrating that the process was unfair to them, which I find fascinating because typically we like to think of the power dynamic there between well-resourced companies and communities that are harmed as sort of a David and Goliath. And in a way, I think the defense's reaction captures perfectly sort of the winning strategy in these kinds of cases, which is to try to build power through cooperation between affected communities, civil society, and law enforcement. And I think that hopefully we had some success. Maybe Gabriel has more to share on that.
Yeah, I would like to highlight a point about the amicus and the issue of delay. As Roy said, the amicus and our claims about the undue delays in the case are not related to or strictly connected to what happened before 2005. We are saying that most of the different judges who were involved in the case, they are not advancing the case and they are provoked in some human rights violation in terms of access to justice. But from the beginning of the investigation, and that's something relevant to give you an element of context. Most of the defendants in this type of cases, transitional justice cases, either state officers or private defendants, they are reaching a point where they are get unfit to stand on trial or they pass away. So there is an inertia that has been even denounced by the Attorney General office in which some judges prefer not to move forward the cases. So no getting to conviction, not getting to a point where they say that the defendants are innocent of any charges. So they put the cases in what we call a stop motion, where things move, but when you see the long term, they are not moving. That's the strategy we claim from some judges that they prefer not to move the cases, but they know that if they get to a point where they release from charges to the defendant, they will get a lot of a negative repercussion in the public debate. So they shelved the cases in a way to avoid public exposure and also some political and economic pressure. So the amicus was very timely because we reached a point where we got to an appeal tribunal to decide on the issue of delay, and there was no further tribunal to review this. So their Amnesty and other, the European Center for Constitutional and Human Rights from Germany and some Argentine NGOs, they put a lot of pressure there. And we here in Argentina, we devised a media campaign also to pressure that tribunal, pressure in a good sense, to get to unblock the case. So it's important. We call in Argentina the biological full stop. Full stop would mean no more trials, but not because of legal reasons, only for biological reasons, because the defendant get unfit to stand in trial. So I think that it's important to have in mind why it was so relevant this moment on the proceedings.
So from that, what would you say, Gabrielle, the kind of general lessons that other organizations or NGOs that want to pursue this kind of legal action against corporate crimes should take? Because this is a specific example with Argentina, but we see the same kind of thing replicated in other countries. What would you say the most important thing is that you learned about how to do these cases and when to call in kind of the
Big guns.
big guns? Yeah, I want auxiliary troops. I had the Dutch word for auxiliary troops in my brain and couldn't get to the English. So when to call in the big guns and get this kind of outside perspective, and also avoid being seen as an NGO that is kind of driven by outside interest, which also never plays well or is sometimes used against NGOs.
And I think that there are many lessons, but one important thing is that Latin America has at least around 60 or 70 ongoing cases related to corporate crimes in different countries. So it's the most prolific region in terms of prosecuting cases related to gross human rights violation committed in context of dictatorship or civil conflicts. That tells something. One of the lessons from Fronterita and those cases is that courts in the judiciaries on the global south are very active. Not because maybe the judges, but because there is some kind of capacity within human rights movements to push forward these type of cases. And those cases are usually connected to the traditional transitional justice cases. So human rights NGOs advocating for these cases are also people who have been prosecuting and pushing forward cases for the last 20 years, even during the impunity times in many of the Latin American countries. So the lesson is that when you have a national human rights movement in partnership with international NGOs and you can devise coordinated strategies, things could be very, very beneficial to create this bubble in which judges or public prosecutors were when they are not very active in prosecuted cases, they see around the bubble and they say different actors look at them from outside, from media, from your neighbors and regular local people who are based on the city where you are prosecuting. So I think that the lessons is not too nice in the sense that it takes time and a lot of resources and efforts, but also it shows that some coordination between what we already have here in Latin America and also what we have at the international level could play a very interesting role pushing forward cases.
Roy, you wanted to join in with your answer also?
Yeah, I just wanted to follow up on that and mention that in addition to the really important lesson that Gabriel just mentioned, another kind of corollary to that is that the value of cooperation between both local and international civil society and law enforcement where appropriate. Now, there are circumstances where law enforcement is entirely adversarial or it's too risky to engage with them. But on the whole, my sense is that law enforcement in Latin American jurisdictions are far more willing to engage with civil society than, for instance, their counterparts in Europe and the United States. There's a pervasive culture in the global north of law enforcement being totally independent and apolitical, which is important, but taken to an extreme, it could actually harm the prospect of them bringing these kinds of cases because they miss out on incredibly valuable sources of information, of evidence, of leads that comes out of civil society actors and out of potential cooperation with them. And I get the sense that there's far more openness to engagement with law enforcement in Argentina, in Brazil, in Colombia that has led to this proliferation of cases that Gabriel is talking about.
A lot of these cases seem to also be based on evidence coming from truth commissions and these kind of national proceedings to get to a certain joint history. Can you, either one of you, say something about the importance of those kind of truth commission findings? Could that also be a reason why, for example, South America, you see a lot more of these actions because you have this basis of this truth commission where part of that was already hashed out and that is not so prevalent in Western Europe yet?
I think that partially, yes. For example, in the case of Brazil, you can see a very strong truth commission which collected a lot of information about corporate accountability or the corporate complicity, and you have more or less 160 mention of private actors contributing to the Brazilian dictatorship. So that is huge. And then after that, that information was used by the public prosecutor office and unions and workers organizations to push forward some cases. Brazil in this moment has at least 12 prosecution against companies. And we can talk later about Brazil, which is a real case due to the legal system. Then you have Colombia. Colombia had its Truth Commission report 2 years ago, and the corporate complicity cases precede the Truth Commission. And actually, the Truth Commission collected information based on the prosecutions that were investigated through the different transitional justice mechanisms that they had in Colombia. And the third example is Argentina, where you have the Truth Commission that collected information, for example, about the Ford case, but in other cases, no. That is the partial response, partial yes. The other thing is that how valuable is collecting evidence through any state mechanism, not only Truth Commission. For example, for the Fronterica case, our strategy was to select the case, La Fronterita, and the type of claims that we would push forward in court based on previous trials against actors, where some evidence was collected for those trials against a state actor, but they were useful to prosecute private actors. And what we did, we sit with a bunch of researchers to go through all the past files of different trials and review what we could get there. So the evidence that you can collect in the past and that go through an institutional state agency give you much more leverage. So either trials, truth commissions, some report by, stock exchange agencies, money laundering agencies, so on and so forth. They collect a lot of information. So what we learn is that to commit crimes against humanity in a systematic way requires money and support. And the state keep track of that support, either financial or physical. The information is somewhere. So when you can research that, because imagine to implement a clandestine detention center, you need some infrastructure. You need someone to put the lights, you need someone to clean the place. So you need to say that you need X money to do something. And that is somewhere in the state. So it is very important to think that the evidence part of the case doesn't start during the trial, it starts very earlier, and you have to be strategic from where you can withdraw from Truth Commission, other trials, or other type of state reports.
Roy, building on what Gabrielle's just outlined there, I'm wondering what kind of evidence do you see is needed to make one of these cases a success? I mean, I'm thinking particularly about linkage evidence, because you're trying to go for the very top of an organization. We know how difficult that is in the international criminal tribunals that we cover when they're looking at a top army or a top political leader, and then it's things like insider witnesses, it's documentation, etc. Can you talk us through what's needed in these cases?
Obviously, we're talking about criminal cases which have the highest evidentiary standard. Eventually, if a prosecution goes forward, they would need to convict beyond a reasonable doubt. And so you need to have really strong evidence, as you said, linkage evidence that links the particular corporate perpetrator to crime base, or to what, maybe in this case, if it's a complicity case, what the state was actually perpetrating. And
But Roy, can I just ask you to really come in there a bit more also on, because I have in my mind, it's what I'm used to is that they should have had reason to know. That's often with a kind of a senior military person, that they didn't stop somebody from doing something. That's enough. Is that the same in these kind of cases? Not only that they might know, but they should have known, or that they should have stopped people, or they should have punished people, or something like that. Is that also the same kind of basic in this kind of case?
standards vary depending on the law in a particular jurisdiction, but generally, if we're talking about international crimes, what you'd have to show is some sort of knowledge or intent. I don't think typically should have known is not good enough to put a corporate perpetrator in prison. And therefore, you have to figure out what they actually knew or what they actually intended. And that requires getting into the minds of what was going on within the corporate actor, within the corporation. And that's when you get into things like what Gabrielle was talking about. How do we get access to documents that typically are guarded from within the company? And that can be done in certain ways through truth commissions, through other kind of state access to evidence. Could be disclosure in all sorts of civil litigation. Sometimes we've had documents come out in civil litigation that are then used in prosecutions. And sometimes that involves an inside witness that can tell you what was going on there. I worked on a case for quite some time where actually a shareholder in a company served as an inside witness about exactly what the senior management of the company knew and intended was going on. It's not easy to collect the evidence for these kinds of cases, but it's doable. And I think a lot of organizations are doing that really important work. And you'd be surprised how much civil society can collect. Obviously, we don't have law enforcement powers. We can't go in and tell a company that we got a search warrant, we got to search their entire offices. That's the prosecutor's job. But at the end of the day, there's a lot that we can do, and we've got to essentially persuade law enforcement to issue that search warrant. So we got to give them a sense that there's something worth looking at, that there's really something illegal that this company was involved in.
Gabrielle, you want to jump in?
In general terms, we talk about corporate complicity, and the legal terms of complicity tell us something. But there are other cases that they are not necessarily complicity. They are primary actors. For example, the cases in Chile, actually Chile was, I think, the first country in Latin America convicting an economic actor. And those cases, there are a series of 5 cases. The private actors, they were primarily responsible of the crimes committed because they were at the moment where the torture, the killings, or the disappearance took place. And then in Colombia, there are cases about illegal partnership, asociación ilícita, we say it in Spanish. So the legal approach is different across the region. But coming back to the complicity and the secondary actor and the intent and knowledge, one issue at dispute is whether the knowledge and intent is about the systematic human rights violation plan, or whether it's the discussion about the specific crimes against humanity that took place around the case. That's part of the legal dispute in cases like the Fronteriza. There is a huge distinction about the evidence to prove the 2 different things. That's one issue. And then there is another second issue that is connected to intent and knowledge, is that the defendant could argue that they have their hand tied. Look, they were a dictatorship, they were the rulers of the world, and they put a gun in our head. So I can do nothing. So then they have this kind of defense. So the question there is how much you contributed to the commission of the crime after the dictatorship. Because you have to remember that forced disappearances are part of a continuous in time. The defendant has provided information to Truth Commission. They report to the authorities what happened during the dictatorship, what that was the behavior. So that's another discussion that takes you not only to the moment, when we talk about moment, we are talking about the years of the commission of the crimes, but also the behavior of the defendant afterwards. And their intent and knowledge plays another role in the legal strategy.
We're talking a lot about the people on trial and how you get there and different perpetrators, but very central in your proceedings are the survivors who are also, and the NGOs pushing these proceedings forward. What are the survivors asking for and what can they ask for? In the Netherlands, I see when I see these cases, mainly against the Dutch state, sometimes they have damages claims, but they're always very limited. The Dutch law system doesn't allow these massive American damage claims. So I wonder what survivors can get in kind of Latin American or Argentinian courts, specifically if we're talking about Gabriel's case.
In general terms, most of the cases in Argentina and in Latin America, they go through the criminal justice process. So what you can get is very limited. There is conviction there, but with some caveats. The human rights movement in Latin America has learned that criminal conviction are also restorative justice in the sense that they tells you about something, and that's official history established by a tribunal. So, for example, someone would say, the case of my mother who was disappeared never got into court, but there is a ruling about the neighbor, and that is justice for me. You know, there is a sense of restorative justice. So what most or many people claim is that they want conviction, but they want the state, a court saying that there is a person who was guilty, that they know who were the perpetrators and what were the situation of these under the crimes were committed. And of course, most of the people who have this disappeared relative, they want to know the whereabouts of the bodies. But in general sense, it's like what we expect is conviction as a means to get something else, which is much more restorative justice. And actually, criminal rulings across the country, which included many restorative justice measures in the text of the ruling, like memorializations, acts of, putting in the media that the X or Y was not killed in a regular killing, it was an illegal killing, so on and so forth. So there is something there of how much we can get from criminal prosecution to make it less retributive to much more restorative. It is a challenge, but it's part of the claims around this type of cases.
Roy, you've got your hand up again.
Just wanted to add a little point and just say that, this is something we look at very closely in the corporate crimes handbook. And we interviewed a bunch of survivors of corporate crimes, and we talked to them about whether the cases really provided them what they needed. And one of the things that we concluded as a lesson learned from these kinds of cases is the importance for legal practitioners to really have a community-centered approach where they listen to what the survivors actually need and not just rush to a knee-jerk reaction of let's file a criminal complaint, because it could be that in many cases a criminal complaint may not lead to what the survivors are looking for. But in many cases, a lot of the survivors that we spoke to wanted an opportunity to be in a courtroom and have that senior corporate executive there explain themselves, explain their conduct. Why did they engage in business that harmed the community in this way? And there was some accountability just through the legal procedure of doing that. And there was also, in many jurisdictions, opportunities for getting compensation, for having asset forfeiture that leads to then some damages that are provided depending on the jurisdiction. So it really depends on what communities are looking for. Obviously, some communities may just want the company to stop. Maybe the company is continuing to engage in these violations today, and maybe a proceeding will get them to reconsider.
And Roy, we heard from Gabrielle how many cases there have been going on across Latin America. So, kind of leading continent, let's say. But are they having an influence worldwide? Are they being seen as examples of how to do this?
Yeah, it's a really good question because from everything I know in the field, I agree entirely with Gabriel, and he's essentially the authority on this. Literally wrote the book on it, but that Latin America is sort of a leading region in terms of corporate crimes cases, and the amount of cases brought, in the success and impact that they're having, and it's really not even close. So the rest of the world has much to learn from Latin America, and yet I find that many of my colleagues in the US and Europe often have not heard about these cases. And so we at Amnesty thought it was really important to change that by highlighting them prominently in the handbook and by trying to bridge the gap between practitioners in Latin American jurisdictions and practitioners in the global north. And we do that in a variety of different ways. The handbook is just one of them. We organize convenings, we bring folks together. And I think that we're starting to see that there's a growing appreciation among both European lawyers and civil society and in law enforcement that it's worth taking a close look at what's happening in Latin America.
Aren't you, Gabriel, also seeing that now with Lafarge and the Lundin cases, all of a sudden your expertise as someone who has done this in Latin America is a bit more sought after, or should our European prosecutors and lawyers try a little harder to find you because you could teach them a few things?
I don't think that we have too many things to teach, at least to exchange a learning process. Actually, I think that from 2014, 15, a very powerful but still emerging community of legal practitioners, academics has been working together in Latin America and in Europe. I remember the first time that I got involved, I was a postdoc at the University of Oxford. We got some funding. 12 years after, we have many cases, and those cases, you name them, but then you can track several meetings in which we were participating to discuss the Lafarge case and the Lundin case. Actually, I was with people from the Lundin case last November, and they were talking about Fronterita. So there is a subtle community which is going on there. The lawyers from Chiquita in the US, we know very well to each other. We know the prosecutors in Brazil. We know the historians in Spain, which are pushing and working with lawyers to get what they call the querellas about forced labor and corporate complicity in Spain. So there is a community there. So I don't think that there are many things to teach. It's much more to exchange. And the contexts are quite different because we in Latin America, most of the cases, not all, but many of the cases are going through the criminal path with individual accused or defendants. And in Europe, there is much opportunities to play with not individual accusation, but corporate criminal approaches. And then you have lead aid in the UK going through damages, which is quite interesting as well. So the legal approach is changed a lot, but what we are learning is that the strategies, the mobilization strategies around the courts are very similar. And there is a lot of similarities and strategies that we can share, and a lot of knowledge exchange going on there, which is very profitable. And I think that we got to a point where I can say that a subfield of transitional justice and a subfield of business and human rights has been created over the last 20 years. And that is the corporate crimes field related to crimes against humanity in general, with a particularly tone on civil conflict and authoritarian governments.
We only have so much time to devote to the podcast each time, and it's never long enough because there's plenty more questions that we would like to ask. But we're going to kind of begin the wrapping up now. The first question we like to ask is there something that you wanted to have said that you haven't had a chance to do so? I do want to push Gabriel a little bit towards, in his answer, if it's possible, to tell us also what's going on with the La Fronterita case at the moment, what we should expect. So maybe start with you, Roy. What else would you have wanted to say if we'd given you much more time?
Well, I mean, there's so much to say. We've covered plenty of ground, but we could talk about this for hours. For now, I'd just leave listeners with sort of the biggest lesson learned from our study of corporate crimes cases, which is that there's hope for overcoming the impunity that companies generally experience. But that hope comes from cooperation, that affected communities, civil society, legal practitioners, and where appropriate, law enforcement officials can come together and hold the perpetrators of corporate crime accountable. That's really the key. And to learn more about how to do that, I'd encourage listeners to have a read of the handbook. And also, please feel free to write to me in any way. Find me on LinkedIn. One of the things that Amnesty does is support organizations developing these kinds of cases. And so we'd be more than happy to speak with you and to find ways that we could support your important work.
Okay, touting for business. There we go. Well done. Gabriel.
Okay, I will be very short, I promise. I think that the main issue here and my main interest at these times is the Fronterita case. We have been waiting for the tribunal to set the date of the start of the trial, the proper hearings, for 2 years. So you can imagine that the tribunal takes 2 years to tell you when you start with the hearing. Imagine what is the mind and the heart of the victims and the survivors for 2 years, after 10 years of prosecution. So the Fronterita case needs some support to pressure the tribunal to set the date. We had what we call the preliminary hearing in December. Just before to start preliminary hearing, a judge withdrew himself from the tribunal. Only 1 minute before starting the hearing. That means that there is no willingness to put forward. So now, after the preliminary hearing, we are waiting an appeal tribunal to decide, appoint a new judge. So things are, it's like crazy. So we are at the moment where we feel that we need that support, and the local tribunal knows that someone is watching at them. And in this political context in which national governments across Latin America are tending to be more right-wing leaning, they know that authorities are not going to make this tribunal accountable. So it is civil society and media which has the key role to make them accountable for setting or not the date to start with the trial. I'm not talking about a ruling. I'm talking about that we want to get them on trial.
Yeah, you would think that a trial date is the least that you can expect. But yeah, obviously from how you explain it, that's not always how things go, especially in some of the countries we cover. Thank you both so much for telling us all of this. I know there is much more you would like to have said, but we'd like to keep it to about 45 minutes. But we do always end our podcast with our asymmetrical haircuts questions. And I am still touting one that I came up with that Janet is not entirely sure of. And that is that I would ask you what your first job was, not necessarily in the field, but if you have a job that was really foundational to what you do, or something that has nothing to do with the field. I'm asking this question also to show people that you can get to international law and reporting on it, or being a lawyer, from very many different angles, and we don't all have to be interning for some kind of judge and the first go, but we can also do lots of other things and still end up doing this job. So that is kind of the context of this question. So, Gabrielle, is there any job that you've had or have that would qualify as a fun story or an inspirational story?
Thank you. One of my key jobs in my career at the very beginning was to work for a tax agency, provincial tax agency in Tucumán, because they gave me a salary so I could spend most of my day working on human rights. But after I ended my job in the tax agency, at that moment, being an activist didn't get you a salary. So having a securing a salary, working for 6 hours for them allowed me to start my career as a human rights activist. So the tax revenue agency was crucial for me.
Thank you to the Tax Revenue Agency for keeping you going, Gabrielle. Roy.
My first job was as a college student, as a bartender. So I don't know what kind of inspiring story that is, but I'd say the job that best kind of shaped the career that I have today is actually that I founded my own organization, the Global Echo Litigation Center, a number of years ago, that brings strategic litigation against companies involved in human rights violations in occupied Palestinian territory. And I think that this is a route that I wouldn't recommend to everyone, but it's interesting to work in sort of the human rights startup space. And I learned a lot from that experience. So, for those of you that are up for the challenges of doing that and the incredibly long hours, then maybe that's a direction you'd like to explore.
And we also always like to ask our contributors, what are they reading or listening to or watching that they would like to recommend? It can be something in the field, or it can be something that you use to get away from the field. Let's start with you, Roy.
Well, I don't know how well the other lawyers do it, but ever since law school, I've had trouble reading for enjoyment. So I do more of listening to podcasts like Asymmetrical Haircuts and audiobooks. Lately, I've been listening to Ronen Bergman's book, Rise and Kill First. It's about Israel's history of targeted assassinations. So maybe different than the corporate context, but still in the human rights space, or, as we call assassinations at Amnesty, extrajudicial killings. Essentially, it feels all the more relevant today as we see Israel's policy of extrajudicial killings kind of expanding without end in recent years. And so it's a really interesting history of it that not only touches on ethical or legal issues, but also on just whether this policy is effective in any way.
Gabrielle, what is on your nightstand, or are you only reading for work?
No, I'm reading right now biographies. I like to read biographies. I would like to write biographies at some point, particularly those biographies without no happy end, the dark part of the story of people. Virginia Woolf, Jorge Luis Borges, Jose Ingenieros. I like writers mostly, and to understand the sequence of failure, that supposedly failure. So that's my inspiration at night.
Oh, wow. So you're reading about essentially failing upwards, or using failure to write the heartbreakingly beautiful literature. Well, I guess in a field where we encounter sometimes a lot of failure, it's maybe a good inspiration. That is, it's one way of going about getting inspiration.
Good and challenging suggestions. So, Gabrielle and Roy, thank you for making time on a Friday afternoon towards the end of January. And we really appreciate that you are prepared to be asked all of these kind of questions, because, it's not everybody who wants to have journalists poking around and trying to understand better what they're doing. So we appreciate you making the time.
Thanks again for having us. And we really appreciate your interest in this work, and look forward to seeing a podcast episode come on.
Thank you, guys. Bye.
This was Asymmetrical Haircuts. your international justice podcast, created and presented by Janet Anderson and Stephanie van den Berg, in partnership with the Hague Humanity Hub. Music is by autonautics.com. You can find show notes and everything about the podcast on asymmetricalhaircuts.com. This show is available on every major podcast service, so please subscribe, give us a rating, and spread the word.